Let's jump right into this explainer. Back in 2006, the South African Constitutional Court found itself staring down an absolute powerhouse of a dilemma. We are talking about a monumental clash that pitted the massive reach of modern media directly against the rock-solid foundational guarantees of the justice system. It's one of those rare scenarios where the core values of a democracy basically collide right in the middle of the highest court in the land. And honestly, it forced everyone to completely reevaluate what a public trial even means in our modern era.
Which brings us to the big, difficult question at the heart of all this. When high-profile justice is on the line, should the cameras be rolling? Today we're diving into this intense, real-world collision between your right, the public's right to know, and a defendant's absolute right to a fair trial. When literally millions of people want to watch a major legal drama unfold, how do we figure out just how much access is too much access?
Okay, here's how we're going to break this all down today. 1. The broadcasting battle begins. 2. The freedom of expression. 3. The fair trial guarantee. 4. A clash of rights. And finally, 5. The final verdict.
Let's jump into Section 1. The broadcasting battle begins, setting the stage. All right, so our story kicks off in 2005. A man named Schabir Shaik was convicted of corruption and fraud and handed a 15-year prison sentence. Now, this wasn't just your run-of-the-mill trial. It was massive. It was a high-profile case involving payments allegedly tied to the country's former deputy president. So as you can imagine, public interest was absolutely through the roof. Shaik appealed the decision, and that super highly anticipated hearing was scheduled for September 2006 at the Supreme Court of Appeal. Well, just a month before that, in August, the South African Broadcasting Corporation, the SABC, stepped up with a completely unprecedented request. They wanted to bring live microphones and cameras right into the courtroom to broadcast the entire appeal on national TV and radio. This was a really bold push to throw the doors of the appellate court open wider than they'd ever been before.
The Supreme Court of Appeal countered with what was basically a silent compromise. They said, okay, visual recording is permitted, you can bring cameras in, but absolutely no sound recordings, which lined up with their standard practice at the time. Well, the SABC flat out rejected that. They argued that a broadcast without sound was just entirely insufficient to actually inform the public about all these complex legal arguments. I mean, they demanded full live audio and video access, or, at the very least, they wanted the green light to broadcast delayed highlight packages that actually included the real audio of the proceedings. So when the lower court stood their ground on the sound ban, the SABC didn't back down. They escalated the whole fight and took their appeal all the way to the Constitutional Court.
Moving on to Section 2, the freedom of expression, the case for the cameras, looking at Section 16 of the Constitution. So the SABC really anchored their whole argument on this core constitutional principle known as open justice. They argued that court proceedings have to be open and accessible to the public to ensure accountability and fairness in how justice is administered. And if you think about it for a second, transparency is exactly what keeps courts accountable to the people. In today's society, just keeping the physical courtroom doors unlocked, it's not enough. The SABC's point was that true transparency means letting the public actually see and hear the arguments exactly as they play out, because otherwise, the public is essentially left in the dark about how a major branch of their own government is operating. To really drive this home, they leaned on a powerful premise, arguing that the proper functioning of a modern participatory democracy requires that the media be free, active, professional, and inquiring. Basically, the media serves as the eyes and ears of the public, right? If journalists are blocked from recording the actual spoken words of the judges and the lawyers, their ability to actively and professionally inform citizens is just severely handicapped. The core argument here is that you literally cannot have a fully informed electorate if the press is handcuffed in how they can report on monumental legal decisions. 18 million. That's a massive number. That was the estimated television audience in South Africa at the time. The SABC used this number to point out that since the vast majority of citizens get their news from TV and radio instead of print newspapers, broadcasting is just vastly more vital for open justice. You can't just rely on print journalists when 18 million people depend on the spoken word and moving pictures to make sense of their world. For a huge chunk of the population, if it isn't broadcast, it might as well have not happened. So turning off the microphones effectively shuts out 18 million citizens.
Let's shift gears to Section 3, the fair trial guarantee, the case for the defense, under Section 35.
So the opposition, which included Shaik's defense team as well as the state, pushed back hard, focusing on Section 35 of the Constitution. They argued that bringing cameras in is a real double-edged sword. Yes, it brings light, But that intense exposure can blind the participants and totally compromise the trial's integrity. They argued that broadcasting adds a massive psychological burden, a stress all its own on the participants. Plus, having live audio and video rolling can seriously inhibit the free, spontaneous, and sometimes aggressive debate that needs to happen between appellate lawyers and judges. And there was another huge factor here. Because this case involved former Deputy President Jacob Zuma, who had his own upcoming trial, the court was deeply worried. They feared this intense televised scrutiny would intimidate future witnesses who might just refuse to testify after seeing the broadcast, and that it could create a public perception that Zuma's guilt was somehow being prejudged in the court of public opinion. The Supreme Court of Appeal made their priorities crystal clear on this one. They essentially said, look, when an accused person is facing a loss of liberty, in this case potentially 15 years behind bars plus some massive financial forfeitures, their right to a fair hearing absolutely cannot be compromised. The media can go gather news pretty much anywhere, but an accused person, they only get one shot at justice in that courtroom. So as the court put it, were anyone to have to give way in this clash of rights, it absolutely should not be the accused litigant.
Which brings us to Section 4, a clash of rights. The referee steps in.
We are looking at a direct, undeniable, head-on collision here. Over on the left side, you've got Section 16, freedom of the press, the media's right to impart information, and the public's right to receive it. And on the right side, you've got Section 35, the accused's ironclad guarantee to a fair, uninhibited public hearing. The catch? Neither of these rights is absolute in a constitutional democracy. So when these two massive fundamental rights are at odds, it creates this incredibly delicate balancing act. How exactly does a democracy decide which right takes the front seat without tearing up the very foundation of its legal system? To figure this out, we have to look to the referee of this dispute, which is Section 173 of the Constitution. This section gives courts this unique, inherent power to protect and regulate their own process, making sure to take the interest of justice into account. And that word, inherent, that's the key right there. It means the courts don't have to go asking for permission to manage their own environment. That power is just baked right into their DNA. The Supreme Court of Appeal used this exact inherent power to ban the audio recordings in the first place, deciding that in their specific courtroom, live microphones would be a direct threat to the fairness of the appeal.
So when the SABC asked the Constitutional Court to overturn that ban, the High Court laid out a specific step-by-step test. First, they have to reconcile those fundamental rights with the absolute obligation to ensure fair proceedings. Second, they have to ensure that any restriction is proportional to the threat. In other words, is banning audio a reasonable response to the fear of witness intimidation, or is it a total overreaction? And third, and this is a big one, the Constitutional Court stated that appellate courts should only step in and interfere if the lower court made a demonstrable blunder. If the lower court made a reasonable, proportional call to protect its own process, it's not the higher court's job to play Monday morning quarterback and second-guess them, unless the mistake was just completely egregious.
All right, let's wrap this up with a Section 5, the final verdict, majority ruling versus the dissent. The majority of the Constitutional Court ultimately decided to uphold the ban on sound. They drew a very clear line in the sand. Live or recorded sound broadcasting should not be allowed, unless the court is fully satisfied that justice will not be inhibited. By putting the right to a fair trial first, the majority ruled that the lower court acted totally within its discretion. No demonstrable blunder was made. They actually acknowledged the massive societal impact of television, but they concluded that slicing up complex legal arguments into quick little sound bites for the nightly news carries this huge risk of turning serious proceedings into trivial public entertainment, which they felt could really damage the administration of justice.
But hold on, because it wasn't a unanimous decision. Deputy Chief Justice Mosenike offered a really powerful dissenting view. He pointed out that the majority's test unfairly gives the fair trial right a massive head start right out of the gate. He argued that an outright ban on sound doesn't just manage the courtroom, it actively silences speech. He really pushed back, arguing that the court was just heavily speculating, basically guessing that highly experienced judges and seasoned lawyers would somehow get stage fright and be too intimidated by microphones to do their jobs properly. And for him, that argument just didn't hold water.
Mosenike was incredibly passionate about this. He quoted historical precedent, arguing that publicity is the very soul of justice. It is the keenest spur to exertion and the surety of all guards against improbity. So, in stark contrast to the majority being afraid of turning the trial into cheap entertainment, Mosenike believed that unfiltered live broadcasts actually shut down public suspicion by letting citizens see and hear the absolute truth directly. He argued that silencing the audio did a massive disservice to the millions of people who completely rely on radio and TV for their news, effectively locking them right out of a vital democratic process.
So what was the final result? Ultimately, despite that really strong dissent, the SABC's appeal was dismissed. The final order only allowed for silent visual recording. But the court did make a really important point about the future. They recognized that as technology keeps advancing at breakneck speed and electronic media becomes even more everywhere all at once, the media and the judiciary are going to have to figure out how to work together to modernize courtroom access. A new forward-looking framework is definitely going to be needed to balance these rights in our increasingly digital world.
Which leaves us with this final thought for today's explainer. As technology continues to evolve, how can courts protect fair trials from the massive pressures of public spectacle without shutting the public in the dark? It's a delicate balance between transparency and justice, and it's a question we'll undoubtedly be grappling with for years to come.